not disturbed during their presentations. And the first case on the docket is John Leonardo versus State. And you may proceed when you're ready, sir.
Good morning.
Morning.
May it please the court, my name is William Pinnell and I represent the appellant John Leonardi in this case. I would request that the court reserve 5 minutes of my time for rebuttal.
All right.
It does not appear that the time is working at this.
It says 5 minutes on there.
Okay. Mine's not working.
It's not registering. Okay, I'll let you know.
Okay, appreciate it. As noted in this brief, it's our position that this court should reverse Mr. Leonardi's conviction in this case for 3 reasons. One being that there was numerous improper comments by the prosecutor during closing argument that deprived Mr. Leonardi of a fair trial and constituted fundamental error. 2, that the trial court erred in refusing to grant a judgment of acquittal because the circumstantial evidence presented by the state was insufficient to support a guilty verdict in this case. And 3, that the trial court committed error by permitting the state to introduce the testimony of Deputy Devlin regarding Mr. Leonardi's statements to the deputy that he was an avid golfer.
It constitutes some sort of slander per se, isn't that?
Yeah, sure. Apparently, if you like golf, that means you steal golf balls from a condo. So apparently that is correct, as some sort of slander to be a golfer. So it's our position that for those 3 reasons that the convictions in this case should be reversed. If the court were to grant the argument on the JOA, Mr. Leonardi would be entitled to be discharged from prosecution. I'm going to spend a majority of the time talking about the improper closing arguments, but I certainly invite the court to ask questions on the other 2 issues. It's our position that, and we concede that all the arguments on closing argument are under the fundamental error standard because there was no objections raised by Mr. Leonardi's trial counsel in this case to those arguments, improper arguments we've identified in the briefs. It's our position that the cumulative effect of the 6 different improper arguments rise to the level of fundamental error in this case and support reversal because they deprive Mr. Leonardi of his right to a fair trial. We start with the idea that the case involved essentially 2 possible scenarios. The homeowner, the condo owner, says that no one had access to his condo while he had left the area and locked the door. But we have a defense witness, the sole defense witness, who says that himself and Mr. Leonardi were let into the condo to inspect the condo for termites. So during closing argument, the prosecutor provides his personal view of the credibility of the sole defense witness by saying, I think he was less than honest and straightforward. In the state's brief, they conceded this was improper.
We submit that the witness was not credible. That would have been okay?
I think that would have been closer to being okay. I think that would have been less improper. I think when he says, I think, that clearly indicates to the jury that he has some knowledge or some inclination to believe that...
Said the witness is a liar. Would that have been okay?
I don't think so, Your Honor.
I think there's a Florida Supreme Court
I think there's a case on point that says that that's improper to actually call the witness a liar.
A case that says that it's okay.
Okay.
Mm-hmm.
I think
what's the difference really as a practical matter in terms of our determination of whether fundamental error occurred and whether it was a harmful one? What's the difference between saying we submit that this witness is a liar or saying I think the witness is not telling the truth?
I think the case law is clear that it's when it's personal to this particular prosecutor that then it's improper, and that the jury attaches some level of sophistication and some level of authority to a prosecutor who represents the interests of the state of Florida and gives that person deference. So when he says I think, the case law is clear it's improper, and in fact the state concedes that fact. And we would agree that that alone wouldn't rise to fundamental error. It's only in combination with the other five improper comments that rise to the appropriate level in this case.
Well, that's your worst one though, right?
I'm sorry?
I mean, that's the most compelling one.
I'm not sure that's the case. I think that's just one of 6.
You always should tell us about the most compelling things first. So what's the most compelling argument you have on the closing argument thing? What was the worst thing that the state attorney did?
Your Honor, I think there's two, but the two most egregious would be that during rebuttal, the prosecutor indicates, and this is at page 219 to 220 of the record, that the fact that there's 11 fingerprints on pizza flyers inside the condo doesn't matter because those fingerprints are just just from someone else that was working in concert with Mr. Leonardi. There's no evidence of that. If that's facts, not an evidence, it's not supported by a reasonable inference. So instead of, it's offered to rebut the idea that there was some other person that broke into the condo, but there's no facts to support that there was someone working with Mr. Leonardi. So now the prosecutor's portraying this idea that there's some conspiracy or two people working together to rob the condo when there's nothing to support that. In fact, based on the state's motion in limine, we knew that the state knew that wasn't the case. They had identified one of the individuals whose fingerprints were on the flyers and indicated that there was no connection, or failed to indicate there was a connection with Mr. Leonardi. So they knew that was false, and they gave this misleading impression to the jury. So I think that's improper and probably the most egregious part of the record on closing argument. And the case law is clear that it's improper for the prosecutor to refer to extra testimonial facts or make unsubstantiated arguments or arguments that are not supported by a reasonable inference. There's nothing in the record that allows the prosecutor to argue or infer that someone was working with Mr. Leonardi, and that's how the fingerprints on the flyers got there. So that was improper, and I think supports the finding that there was fundamental error in this case.
Well, the most probable inference is that whoever handled the flyer before it got distributed, his fingerprints were on there, right? I mean, obviously somebody handled the flyer before it got
but the important,
right?
That's one possibility, but I guess the reason why the flyers are important is that the homeowner says that no one had access to the home.
Right.
Well, now we know that's not true because the flyers are in there and they weren't there before. So, and there's 11 fingerprints.
And his prints weren't on them.
They were not. So it's also consistent with the idea that someone who moved the flyers around was someone else, one of the 11 other fingerprints was involved in this burglary.
Where in the home were the flyers located?
The flyers were located, I believe, in the entry to the home, in the foyer area, and I also think...
Was there evidence as to whether they could have been slid underneath the door?
I don't believe there was evidence presented either way. I'm not sure on that fact, Your Honor, but I think there was flyers in the entryway and also some other place of the condo as well. So I think the presence of the flyers in the other area of the home would suggest that did not occur, at least for those particular flyers. The other indication, the other improper statement of fact, which effectively reduced the burden of proof and misstated the burden of proof, was on page 221 of the closing argument. The prosecutor indicated that the mere fact that Mr. Leonardi's fingerprints were inside the condo, quote, proves beyond a reasonable doubt that he was in the apartment, that he was taking things, and that he entered and exited through the window. And again, I don't think, based on the evidence, that's a fair argument. There was testimony that provided an explanation, a reasonable and legitimate explanation for him to be in the condominium to do the termite inspection. The fact that his fingerprints is...
Just to ask you about that.
Sure.
I thought the homeowner testified that he had changed the lock or something so that not even the condo maintenance people had a key, and that Mr. Leonardi's witness, Mr. Gregg, who worked for the pest control company, testified that they went into a number of units in that complex, but could not recall specific units. He couldn't say, I absolutely know we were in this unit. He could only say, we worked together doing inspections, and we went into a number of units.
That's part of his testimony. The other part of his testimony that matched up to the homeowners was that they did a termite inspection on a home or a condo where the deck was being repaired, and that Gino, the foreman in charge of that deck repair, was the person that let him in. So it matched up. I mean, the homeowner,
But I thought the homeowner said that Gino, the maintenance man, didn't have a key to his unit.
he did say that, Your Honor. He said that, Your Honor, but it was inconsistent with the idea that these flyers were found in the home, so someone had access
Not
to.
necessarily inconsistent, but let me ask you about the fingerprint on their golf balls in a closet, and they're apparently fairly up high on a shelf, and the 3 or 4 boxes of golf balls were stolen, but the Pink Ladies were left behind with your client's fingerprint on them. What's the reasonable explanation for his fingerprint on that, on the Pink Ladies?
Well, the testimony, Your Honor, from Robert Gregg, the co-worker at the Middleton Pest Control, was that they did a termite inspection of these condominiums, and they inspected the entire units, inside, outside.
Worried about termites in the golf balls?
Well, I guess the idea would be that they're inspecting the closet where the golf balls are, and you may be inspecting the ceiling, and as you're standing on a ladder or looking up, your hand could touch the golf balls up on the shelf. I mean, certainly when you're in a closet, you're going to touch items other than the wall if they're stacked up against the wall, or they're stacked up high on a shelf. If you're looking at a ceiling or a wall.
Is there evidence as to that, or that's just...
Well, no, the testimony was that the termite inspection was on the exterior and the interior of the condominium, so I think it's a fair inference that in an internal inspection of a condo, you could touch items in the condominium.
You got a little less than 4 minutes left if you want to say some time for rebuttal.
Sure, Your Honor. I reiterate my arguments in the briefs. I would also argue that the trial court erred in refusing to grant the JOA. I think that this court's Knight case is not right on point because I think the evidence is solely circumstantial in this case. I think that case is in conflict with Jaramillo, so I think a JOA was appropriate based on insufficient circumstantial evidence in this case, and I'll reserve the rest of my time for rebuttal.
All right, sir, thank you.
May it please the court, my name is Charlene Matthews on behalf of the state of Florida. I'd like to start with the JOA argument. This issue is not preserved for appellate review. At the close of the state's case, the defense merely argued that the state had failed to establish a prima facie case as to the burglary of the dwelling, the grand theft, and the criminal mischief, and failed to establish the damage amount for the criminal mischief. At the close of all of the evidence, the defense then just renewed the motion for JOA. There was no argument made that the state's evidence failed to rebut every reasonable hypothesis of innocence in this case. And so that argument is not preserved for appellate review. The fundamental error analysis is whether there was a crime committed here at all, and certainly the state did present sufficient evidence that a crime was committed based on the victim's testimony as well as the fingerprint evidence. Going to the prosecutor's closing arguments, none of these were preserved for appellate review. So again, the fundamental error analysis applies, and it would be the defendant's burden to prove that the comments either individually or in concert utterly destroy his right to a fair trial, and he has not met that burden in this case.
But do you agree or disagree that some of the comments were problematic?
I believe...
I don't think we get to a fundamental error analysis unless there's some error to begin with.
Yes, sir. I believe, number one, that they weren't objected to because the comments were not objectionable. The first comment that appellant discussed was the comment about the defense witness being less than honest and straightforward. This court in Rivera has noted that it's not the vernacular that the prosecutor uses, or anyone uses for that matter, but it's the actual message. And I think it's clear when you look at that prosecutor's, when you look at that phrase in context, the prosecutor was drawing the jury to the way that that witness answered his questions on cross-examination and characterizing them as less than honest and straightforward. So he directed the jury to the evidence in that case, in that comment. Regarding the comments regarding the fingerprints on the pizza flyers, that was certainly fair reply to the defense's closing statement, where the defense attorney in her closing statement talked about the pizza flyers, the prints, and she says those latent prints, the original two, those came back to Mr. Leonardi. Mr. Leonardi was clearly in the condominium. The other flyers had, according to her, 11 prints and 2 impressions. It's not her job to go back and try to investigate and find out who they could possibly belong to. It was just not, but there was more than one person in that condominium. So she's the one who started the thought process or raised the issue that there was more than one person in that condominium. And so the prosecutor's comment that, you know, even if there were more than one person, and you can tell by the prosecutor's comment that he talks about it in terms of a hypothetical, you know, what if someone else left fingerprints that couldn't be identified? And of course, it was, his point was that it doesn't matter because of where the defendant's fingerprints were found in the, inside the condominium.
You acknowledge in your brief that the prosecutors expressing their own personal opinion is improper.
That's correct, Your Honor.
And what is, you know, when he says, I think this or I think that, you know, isn't that exactly what he's doing? Or what she's doing?
He didn't say, I think the witness is lying. I think the defendant is guilty. He specifically referred to the witness's testimony and the character of the testimony not being forthright, not being, and the questions being kind of answered in a fudging kind of way. The statement, I believe, or I think, standing out there on its own, certainly, but again, the case law requires that the comment be looked at in context, and in context, it was not error, and it was certainly not fundamental error. That one comment did not utterly destroy the defendant's right to a fair trial in this case. And so the state's position is that the comments singularly or in total do not rise to fundamental error. We rely upon the additional arguments as set forth in our brief and ask that you affirm. Thank you.
All right, thank you, counsel. Well, you got a little over 3 minutes left, sir.
May it please the court. I respectfully disagree with the state's contention that the JOA argument isn't preserved. I would certainly agree that the motion made by the lawyer could have been more detailed, but the purpose of the preservation is to give the trial court a chance to rule on the specific argument. In ruling on the JOA motion, the trial court said specifically, the state has presented sufficient circumstantial evidence that the defendant was the person who committed the crimes. So the court was well aware that this was a circumstantial evidence case and ruled that there was sufficient circumstantial evidence. So the issue, the court understood it, ruled on it, it's properly preserved in our opinion, so I think you should address the merits of that claim. Claim number 2, that the JOA should have been granted.
Are the fingerprints circumstantial evidence or are they direct evidence?
I believe they're circumstantial evidence, and I'd cite the court to the Jaramillo case from the Florida Supreme Court, where the sole evidence of the defendant's involvement in the case was fingerprints in the murder victim's home. and they applied the circumstantial evidence standard based on the fingerprints being circumstantial evidence. So the Jerry Miller case suggests that that's circumstantial evidence that the defendant committed the crimes alleged in this case. I point to the court to the fact that this is a weak or close circumstantial evidence case. There's no eyewitness to Mr. Leonardi breaking into the condo, no eyewitness to him stealing anything from the condo, no confessions or admissions from him, no evidence that items stolen from the condo or found in his possession, and an innocent explanation for his presence, the presence of his fingerprints was presented to the court, that he was working with Mr. Gregg doing a termite inspection. Finally, during closing argument, the state argued that Mr. Roth has some rights under the law, and he has a right to a fair trial. I'd submit that that's, again, evidence that this was fundamental error. No one disputed that Mr. Roth was the victim of a crime. The sole question was Mr. Leonardi the one that committed the crime? The jury is supposed to determine that fact. They're not supposed to determine whether they feel bad for Mr. Roth because he was robbed. Everybody does that. Everybody feels bad for him. But that's an improper argument to the jury that he's entitled to a fair trial and he's entitled to some sympathy because he was a victim. And that's consistent with the Hall case where they say you can't appeal to the jury's community conscience and their emotions. And by asking them to feel bad for the victim of the crime, that's what the prosecutor was doing in that case. And given all the improper comments and given the close nature of this case, the prosecutor should not have been able to push the jury over the line to a jury verdict when they're walking this line between guilty and not guilty. And that's what happened in this case. For that reason, and because the state didn't present sufficient evidence, sufficient circumstantial evidence to refute the reasonable hypothesis of innocence, I'd ask the court to reverse the convictions in this case.
Thank you, you're out of time, appreciate it.
Thank you.
Thank you for your arguments. All right, next